inconsistent internally, both during direct and cross, and it was also inconsistent with the 2 statements she gave to police after the alleged incident occurred, and those 2 statements themselves were inconsistent. So the state had a real credibility problem at this trial. And so what the state did in closing argument by bringing in these broader issues was improper and reversible even under the plain error standard. Perhaps one of the most egregious statements by the prosecutor came during the rebuttal part of the closing argument. So this is the last thing that the jury hears before deliberations. After the prosecutor has built up this theme of we must vindicate sexual assault victims generally because no one believes them, the prosecutor then closed rebuttal by telling the jury, what you heard from this witness, from this stand, was real, and it's evidence, and it's an accurate reflection of what occurred to her. And Your Honors, we submit that cannot be categorized as anything other than vouching. We know that vouching for a state witness is highly improper. And so in this case, not only is it just the black letter law of prosecutors in closing argument, here are the things you cannot do, here are the things you cannot say. Here we have a prosecutor violating multiple of those rules in a case where it very much mattered who the jury believed. Were they going to accredit the alleged victim's story, or were they going to accredit Mr. Oliver's version? And I would point the court when we're looking, I know because I have to acknowledge we're under plain error, so I don't mean to spend too much time emphasizing the prejudice, but I think that's where this case may fall for the court. And here, as I said, not only did the alleged victim's testimony contradict itself and then was inconsistent with her statements, it was also inconsistent with the physical proof. There were photographs introduced at trial, photographs that were taken of the alleged victim in the days following this alleged incident. And there was some bruising visible, we acknowledge that. But when you read her testimony and her description of what allegedly occurred in this hotel room, she describes a very violent throwing, punching, kicking, slamming, her face ripping, her nails breaking, her teeth being slammed against the floor. None of that is depicted in the photographs that are taken after the alleged incident. So what we have here is her testimony, her statements, not consistent with her own other statements, and then not consistent with the objective physical proof.
But didn't she go to the hospital several days after the incident?
Yes, Your Honor.
And were the photographs taken several days after the incident?
Yes, Your Honor.
Okay.
Yes, Your Honor. And at trial, the trial counsel, even when he was questioning her about some of these, said, what are we looking at here? And so our position is, if this event had occurred to the degree that she described, the injuries would have been far serious, even a couple of days, far more serious in the photographs, even a couple of days afterwards. And I want to be clear with the court, I'm not saying that the prosecutor was not right, that often sexual assault victims don't come forward for fear of being blamed or ridiculed and often aren't believed. Our point is that that kind of theme has no place in a criminal jury trial, particularly where there are inconsistencies, and really the only issue for the jury to decide is which of these 2 people they believe.
Well, let me ask you, Counselor, didn't the victim delay in reporting this incident?
I don't believe it was delayed more than a couple of days, Your Honor. I could be wrong about that, but I don't believe it was more than a few days before these pictures were taken at the hospital.
I mean, could you interpret the argument that the DA's making as an explanation why there was a delay in reporting the incident?
From reading the transcript, I do not think that is a fair interpretation of the prosecutor's intent, just to be candid with the court. I think when you read, I know the court doesn't always read the full record before arguments, obviously, but I think when you read the transcripts, it is very clear that the prosecutor is going for this broader theme of, hey, Lady Justice doesn't always fulfill her promises, and you, jury, get to do that here today. I mean, it was very much this very emotional, passionate, prejudicial argument of justice in general, do justice for not just this victim, but all sexual assault victims everywhere. And that's just highly improper in a criminal jury trial. Notwithstanding what we might say outside of court or have these discussions on a social level, it's just not proper for closing argument in a criminal prosecution. And I think it's clear from this record, too, that the jury was struggling. The jury came back with 3 questions or 3 notes for the trial court during deliberations. And on all 3, the jury indicated, we are not unanimous on count 1. What do we do if we're not unanimous on count 1? We're hung on count 1. And so this jury is clearly struggling with the allegations. And when you have this kind of very close case, I think as the state acknowledged at trial, I'm not sure if the state referenced this in its appellate brief, but I know at trial the state acknowledged this whole case hinges on credibility. I mean, everyone knew that that's what this came down to. And so for the prosecutor to make the entire closing argument from the very beginning to the very last thing the jury heard at the rebuttal argument of, we have to show that we believe sexual assault victims, and what you heard today is accurate. I mean, that is the quote from the prosecutor. From this witness, from this stand, it was real and was evidence. Well, sure, it is evidence. But then for that next step to say it is an accurate reflection, that's vouching, and that is improper.
You're saying vouching being that was the prosecutor's personal opinion? That's what you're stating?
Correct, yeah. Yes, Your
But
Honor.
oftentimes in vouching, we used to see prosecutors say, I've interviewed a lot of victims, and this one's telling the truth. Take my word for it. There was nothing that blatant, correct?
It did not go that far. That's true, Your Honor.
So, while the prosecutor is an advocate for justice, they're still an advocate, correct?
Correct.
All right, and there was a comment on the evidence, what you heard was evidence and it's real. She said so. That's another interpretation of what was said, correct?
So the prosecutor said, what you heard from the witness stand was real, and it's evidence, and it's an accurate reflection of what occurred to her on the dates in question.
Well, she's the one that said it, the victim, right? So if she took an oath and told the truth according to what she said, it's accurate to her. Could that be another interpretation of what the state said?
I don't think that's a fair interpretation of what the state said, respectfully, Your Honor. I just don't. When the entire theme was, we as a society don't believe sexual assault victims, and that's wrong. We need to believe them, and we need to stop blaming them and ridiculing them, and then ending it with what this victim said was accurate. That's the problem, Your Honor.
I understand what you're saying, but we ought to support the system as a whole and support sexual assault victims. That's slightly different than what you're saying is vouching, that the prosecutor's saying this is accurate, it's real, it's what occurred to her.
That's correct. The way that we raised it in the brief were multiple different types of improper argument. So yes, I do acknowledge.
So was there any type of improper argument that you didn't include as being utilized by the state? I counted 6 or 7 types of improper argument in your brief.
Yes, Your Honor.
Deterrence?
The general deterrence.
What part was deterrence?
So we connected that to the broader. I think. Let me back up a second. I think the 2 most obvious improper arguments are the appealing to the passions, the prejudice. Maybe I should say 3. Also, injecting issues broader than innocence or guilt of the accused that is on trial, and then the vouching as well. I think also when you read the entire closing argument, you will see that the prosecutor has this theme of, again, society generally does not believe sexual assault victims. So we need to, I think the line was, restore justice, restore the balance. So there's this image of Lady Justice and her scales not being even in general, and then the prosecutor using this case as a vehicle to get this jury to believe this particular victim, to make sure that sexual assault victims generally are not, quote unquote, iced out of the justice system, which was the argument
So
that was made.
your argument is that this argument by DA clearly violated these rules of law. There wasn't any vagueness or other interpretations. but
Correct,
Your
Your
argument
Honor.
is it clearly violated. Well, what about the other plain error criteria?
Yes, Your
Especially,
Honor.
did you prove that it wasn't a tactical decision?
So the tactical decision, there's Tennessee Supreme Court case law that says basically, unless there is proof that the failure to object or failure to raise it in a motion for new trial was tactical, if the record is silent, then we presume that it was not tactical, that it was an oversight.
Is that the same thing as saying the state has the burden of proving it was a tactical decision?
I'm not sure if the case specifies whose burden it is. Obviously, under plain error review, I recognize it's our burden to prove that all 5 factors are met. Typically, the way that I understand the case law, though, from the Tennessee Supreme Court, is that we've met our burden on that 4th factor if the record is silent as to whether it's tactical or not.
The defense meets their burden if they prove nothing. Doesn't that mean the state has the burden of proving that it was a tactical decision, or otherwise you win?
I think, not necessarily, Your Honor, because I have to meet all 5. But I think the strategy or the tactic prong in this case, not only is there no indication that this was some strategic decision to omit this, I think I am Mr. Oliver's 4th attorney at this point. So there is a lack of continuity in counsel. I don't think it would be reasonable in any sense to say surely there was some coherent strategy here through 3 different attorneys, one, and actually 5, because he had a different attorney at the preliminary hearing, different attorney at trial, and then 2 different private appointed attorneys in the post-trial proceedings, and then our office was appointed for the appeal. So I'm now actually the 5th attorney. So I don't think that this record shows there was any kind of coherent strategy at any point for Mr. Oliver.
I mean, I agree, but the record has no evidence on this point at all.
I think what is in the record supports a finding that it was not a tactical decision to not object during any of this improper argument.
And that's in the record somewhere? I mean, did any of these other 4 attorneys ever offer any testimony?
No, Your Honor, they did not.
So, I'm not sure where in the record it would be any evidence about whether it was a tactical decision. Help me out
Correct.
here.
So I'm sorry, I didn't answer your question very well the first time. There is no direct statement in the record if it is tactical or not. My position is the record shows that there was no coherent strategy that could have possibly lent this to be a strategic decision on the part of any of his attorneys.
Again, it sounds like the state's got the burden of proving it was a tactical decision.
Yes, I understand what Your Honor's point. I guess I would go back to the Tennessee Supreme Court case law that says when the record is silent, we presume it was not tactical.
Any of those cases prosecutorial misconduct cases?
I do not know off the top of my head what the context was. They were plain error review cases for sure, though. Absolutely, they were speaking to that 4th issue. I see my time is up. If there are any further questions, I'd be happy.
You still have 3 to 4 minutes for your
Thank you, Your
rebuttal.
Honor.
Ms. Redding?
May it please the court, Catherine Redding on behalf of the state. The defendant is not entitled to plain error relief based on improper closing arguments. It's the state's position that the defendant has not established the breach of a clear and unequivocal rule of law. And I'll take what I understand to be the 3 claims of improper argument in turn. First, the state did not inject an issue broader than the defendant's guilt or innocence when the state made its comments about justice and ICE, because the prosecutor was not improperly asking the jury in this situation to send a message arguing the need for general deterrence or urging the jury to find the defendant guilty in retribution for common treatment of victims of acquaintance rape. Taken in context, there is a strong argument that the prosecutor was actually reflecting on what had occurred at this particular trial. The victim in this case did offer more testimony at trial than she offered in her statement to police, and that came out and was a point of contention at trial. the defendant elicited proof that the victim was drinking on the night of the offense, that she failed to use the term rape when she described the incident to police, and that the police had trouble locating her for the preliminary hearing. The defendant also attacked the defendant for differences between her police statement and her trial testimony, testified that she had used drugs, that she had prostituted herself for drugs, and was a violent drunk. So there is a reasonable read of the state's argument in the context of the entire trial and in the context of the full argument that the prosecutor was responding to challenges to the victim's credibility. Second, the state did not improperly inflame the jury's passions and prejudices by invoking Lady Justice and encouraging the jurors to put themselves in the shoes of sexual assault victims. My reading of the closing arguments, I don't actually see a part where the prosecutor asked the jurors to put themselves in the shoes of a sexual assault victim, but he does, or she, I'm not sure, but the state does ask the jury to act as the blindfolded Lady Justice, to put aside prejudice and their personal beliefs, and then directly asks the jury to reach a verdict based solely on the evidence. It's the state's position that that does not arise to the breach of a clear and unequivocal rule of law about invoking passions and prejudices. The state was asking this jury to be blindfolded justice, to weigh the evidence that was presented at trial and to return a verdict based on the evidence that it heard. As to the third claim, the prosecutor did not personally endorse the victim's testimony at trial or express a personal opinion as to the veracity of her testimony. And that's what the case law prohibits. That's the clear and unequivocal rule of law. So here, if you look at the arguments taken in context, it's clear that the state was making a comparison between the victim's testimony at trial and the defendant's police statement, and that was drawing a comparison between somebody who's offering sworn testimony at trial and the defendant who comes into the police station and gives an interview saying that the testimony is real and that it is evidence of the defendant's guilt. But the defendant's willingness to give a police statement isn't actually proof of innocence or proof that what he told the police was true, that there are multiple reasons why somebody might go have a police interview. So I think that all three of these claims, you have to take the arguments in context and really see what's going on. And then since we're under plain error review, there has to be a breach of a clear and unequivocal rule of law, and it's the state's position that the defendant cannot establish that. And as to the vouching argument too, I'd also just point out that the defendant, during his closing argument, made extended arguments about on his claim that the victim's trial testimony was inconsistent. So really, the claim in closing was a challenge to the victim's credibility. So taken in context of what happened at trial and what was said at closing, there's no breach of a clear and unequivocal rule of law. The state's position that the defendant has also failed to show that consideration of the improper arguments is necessary to do substantial justice. So even if the arguments were improper, they were not so improper or inflammatory that they affected the verdict to his detriment. So the jury's verdict here was the result of the victim's testimony that the defendant choked her to the point of unconsciousness, then unlawfully sexually penetrated her while pushing his forearm against her neck and punching her, causing bodily injuries in the form of bruises to her arms and pain to her back, neck, and ribs. The jury had the victim's trial testimony in front of it. They had all of the photographs. They heard the explanations of what the photographs were supposed to depict. They heard about the victim's prior statements. They heard the defendant's own testimony, his claims about what had occurred. And so the jury's verdict here was based on a finding that the victim's testimony, setting out what had happened, that was credible. But second, the trial court read the jury instructions right before closing arguments. The jury instructions are not actually in the record, but the pattern jury instructions do include an instruction that arguments of counsel are not evidence. And if you don't think that, if the jury finds that the arguments are not actually supported by the evidence, they should be disregarded. The defendant hasn't offered anything here to show that that pattern instruction wasn't given at least once, if not twice, during the course of trial.
So the jury instructions are not in the record?
No,
Or is there a transcript of them?
not that is included in the appellate record.
So we don't know what curative measures the judge took in this regard?
No, not in terms of any curative measures in the jury instructions. Certainly the defendant.
We normally would anticipate the judge would tell the jury, the judge, the credibility of the witnesses, maybe not to have any sympathy or prejudice, et cetera, et cetera.
Yes.
That what lawyers say is not evidence. These are typical things that might be in, this jury might have been instructed on, and probably was, but we don't know that.
We don't know.
And isn't that a requirement for our plain error review, that we know what the trial judge did to correct this?
Well, I think that, so the record is clear insofar as the arguments made during closing are clear. The record is not clear as to whether there were any curative instructions, as you said.
Obviously, there wasn't at the time because there was
Right.
no objection.
Yes.
But you also factor in the final jury instructions to see what the judge did that may have cured it. And we
Yes.
don't know what that is in this?
No. I also point out the defendant hasn't established that the prosecutor's intent in making these instructions was improper. And if one of the arguments was error, there are no other arguments with which it can accumulate. And the defendant has attacked the strength of the state's case, but it's the state's position that the case here was in fact strong. It consisted of not only the victim's testimony, which was clear at trial as to the details of this particular allegation. It was corroborated by the photographs showing bruises. Yes, not bruises for everything that she said, but there, as you've mentioned, there was a passage of time, and I'm not a medical expert, but I think that a jury could reasonably conclude that maybe some things that happened wouldn't leave marks necessarily. But the jury had...
Ms. Reddick, before you run out of time, I kind of want to take a pivot to something that they did not argue under oral argument here, and that has to do with this fine amount.
Yes.
You point out in your brief that the defendant did not object to the court's imposition of the fine, but you correctly note too, I guess, that the record, there is nothing in the record to be able to say the trial court made any findings on the ability to pay, correct?
Correct.
So I guess what I'm getting to is do we review this question on the imposition of fines by plain error, since there was no objection?
I think this court could elect to review under plain error. Certainly, the defendant did not object to the fines. I'd also point out that the defendant did not offer any proof of his ability to pay at sentencing or before sentencing. So I had not argued waiver. However, I do think that there is definitely an argument to be made that he's waived, especially the consideration of the ability to pay.
Okay. I just was curious about how we review that when it looks like the trial court basically said, at least I haven't read the transcript, but just approved the jury's findings or imposition of a fine without making any other of the legal findings that trial judges are required to make about ability to pay and so forth.
And I just point out that ability to pay is just one of the factors. And by the time that the trial court got to the fines, it had considered a lot of the potential for rehabilitation in the criminal record, these factors that go into fine consideration. And unlike some cases where fines, the approval of fines has been overturned, the trial court did not make extensive findings, admittedly, but it did more than just say the jury imposed this this is the fine. And there are, my friend on the other side has cited to several cases that support the idea that that is not enough, but there are other cases of this court where that has been found to be enough.
I would agree with you. I think that you're saying it's kind of a gray area.
It is. And so if this court were to find that it was waived and reviewed for plain error, then certainly the state's position would be that there's no breach of a clear and unequivocal rule of law, given the fact that we have cases that can come down on both sides. And frankly, the defendants in a failure to provide any information, not only failure to object, but failure to provide any information about his ability to pay weighs against a finding of plain error. So, if there are no further questions.
I do have one question. Do you concede that it's the state's duty to prove that this was a tactical decision under plain error review?
It's the defendant's burden to establish all 5 plain error factors. Admittedly, well, I did not argue tactical error. It's a bit logistically challenging sometimes on closing arguments. I mean, this is not a case, I have seen other cases where a defense counsel has said, makes an objection later on, said, well, I didn't object to this, but I'm going to object to this because it rises to the level of that. And that clearly is a tactical decision. But I'd point out that the fact that the defendant has had 5 attorneys over the course of this case, really, the fact that all 5 of them don't have a coherent strategy doesn't mean necessarily that the trial attorney who represented the defendant at the time of trial during closing argument didn't have a strategy. And there's plenty of case law in this case, albeit a lot of it in the post-conviction context, where it talks about trial counsel's failure to object during closing arguments as a tactical decision. And those cases generally discuss, not wanting to interrupt, not wanting to draw attention to something that the state has said. So I think that there is an argument to be made, and the defendant certainly has the burden of establishing that it wasn't tactical. I think it does become a bit tricky when there's not a lot to work with.
Another way for me to phrase this is, why didn't you prove that it was a tactical decision?
Because I do not have a trial counsel on the record saying I made a tactical decision not to object.
Why didn't you subpoena someone to the trial court?
The state did not, well, I would assume that in this situation that the state did not subpoena anybody because they would have had to anticipate that the defendant would have raised a closing argument, an improper prosecutorial argument on appeal. So they would have to anticipate the defendant's appellate claims while still in the trial court at the motion for new trial stage. And it's not the burden of the state to create a record that allows the defendant to have an easier path to establishing all 5 of the plain error factors. So I don't think it's the state's burden to do this. Certainly,
Well,
the
point I was
ability
trying
to,
to make is you'd have to be clairvoyant.
yes,
Okay.
yes. And unfortunately, that is not always possible. So unless this court has any further questions, the state asks this court to affirm the judgment. Thank you.
Thank you, ma'am. Rebuttal? I think you have your full 4 minutes.
Thank you, Your Honor. I guess if it's okay with the court, I'll start with the fines issue briefly and then sort of circle back to the other issues that were raised. As to the fines, I agree with Your Honor, it is a gray area recently. I think prior to the last couple of years, Tennessee Supreme Court, and certainly still good law, so the Tennessee Supreme Court precedent is clear that the fines are a part of the total overall sentence. Typically, sentencing issues are not subject to waiver. And even after buys, trial courts still have that duty to put sufficient findings on the record. The couple of cases that we cited in our brief on the fines issue, they all reverse and remand for a new hearing after finding that because the trial court failed to put any findings on the record or insufficient findings on the record regarding fines, then the trial court loses its presumption of reasonableness and the abuse of discretion standard does not apply. So all of the cases we've cited are consistent, I think, with the Tennessee Supreme Court precedent that sentencing issues are generally not subject to waiver, and when we're talking about fines, they are part of the sentence. No matter what happened after buys, no matter what relaxed standards we have now on appeal, we still have the requirement that trial courts put their findings on the record. And the Clymer case that we cited in our brief specifically speaks to what the state's argument here today. They made the same argument in Clymer, that when the trial court puts findings about length, manner of service, that's good enough. The Clymer court said, no, it's not. You trial court still have to make findings on the fines, in addition to just like you have to make findings on the other issues of sentencing. So I think that's covered in the brief there. If I could turn back to at one point about the what was actually said during closing argument. So the state, I understood to be a kind of equating defense counsel's argument to the jury that the alleged victim's testimony and her statements were inconsistent, that is somehow the same as the prosecutor telling the jury that her testimony was accurate. And I would disagree with that for a couple of reasons. Number one, arguing that a witness's testimony is inconsistent is arguing the facts in the record. That is making an argument that is based on the proof. But a prosecutor telling the jury what you heard was accurate, that's different. That is a personal assessment, to your point, Judge Wilson. That's the prosecutor giving a personal assessment of that witness's credibility. So that's different from
Wait a second.
arguing.
Did he say that I believe it's personally accurate, or did he just say?
She said, the prosecutor said, I hate to quote it directly and not get it just right, but I know that the phrase was, what you heard or what was said on the witness stand by that witness was real, it's evidence, and it's an accurate reflection of what happened to her.
I guess when words matter here, because some of these are a little more obvious than others.
Sure.
Did the prosecutor say that I believe it's accurate, or this is my personal opinion it's accurate?
No,
or
Your
did
Honor.
Interject themselves, or was this just argument that it was accurate?
It was the prosecutor's statement that it was accurate, but to be fair, she did not say, I think what she said is accurate, therefore you should find the same. It was not that blatant, Your Honor.
So we would have to infer that it's the personal opinion from the lack of saying it was personal opinion?
Yes, and I don't think that's a difficult inference to make when you read the argument in context. I'm almost out of time. If I may make one final point to answer your questions, Judge Ward. Cooper and Gomez that are cited in our brief about the silence relating to the tactical issue, neither of those were closing argument cases. But to your point, Judge Easter, the Enix case, the most recent Tennessee Supreme Court case on improper closing argument in the plain error context, says that it's difficult to show whether it's tactical or not until we get to post-conviction proceedings. And then the Supreme Court ultimately did not reach whether the failure to object was tactical in that case. But I think that's instructive here that it's hard to prove a negative, essentially.
Yeah,
but here,
I mean, in Enix, they had the opportunity to create the rule that you're arguing for, but the court declined to do so.
Respectfully, Your Honor, I think the rule already exists. The rule already exists that when it is, and that's the Cooper and the Gomez cases we cited from the Tennessee Supreme Court. If the record is silent, we presume that the fourth requirement of plain error is met. Enix was just the only one in the context of closing argument I wanted to make the court aware of.
Thank you, ma'am.
Thank you, Your Honors.
Well argued, well brief case, and
Thank
we
you.
will issue an opinion straightway. Thank you. Madam Clerk, next case, please.